So we're here again with Professor Stephen Baskerville of Patrick Henry College. And Professor Baskerville has recently done a talk in Louisiana in the United States at the Ruth Institute. And it's the summit covering issues such as the sexual revolution, which of course goes back to the Woodstock and the hippie days, but in many ways is still with us now. And this was on the weekend of the 27th, 28th of April. And Professor Baskerville, what were the main themes of that talk, and what did you concentrate on, and how well was it received? Could you run us through all those issues, please?
Well, the material comes largely from my first book, Taken into Custody, my earlier book, I should say, which is somewhat updated by the more recent book, The New Politics of Sex. But I went directly after the concept of no-fault divorce, the concept of no-fault justice. And what a truly radical innovation this is in the legal system. There's nothing quite like it. In some ways, I say it's the most radical innovation ever undertaken in the law.
Would you call it innovation or a corruption, do you think?
Well, it's both in many ways. It certainly violates. My theme is that it violates the most basic principles of the common law. For example, the principle, very old principle in the common law, that a citizen who isn't accused of any legal wrongdoing has a right to be left in peace, that you have a right to be left in your own home without being interfered with by the functionaries of the state, unless you've been accused of some legal wrongdoing, either criminal or civil. No-fault divorce is the only legal process by which a completely legally unimpeachable citizen can be hauled into court and issued with directives governing his or her life, for which the person can then be punished legally for violating. So a kind of criminal code is written around the individual by the judge, subjecting that individual to punishment, potentially criminal punishment, for doing things that there's no statute prohibits and that anybody else can do. So that in itself is a pretty legal innovation. It's the only legal process I know of that has a predetermined outcome. When you're taken to court, sued for a divorce, the divorce is always granted, and it's granted without any consequences for the party that has broken a legal contract. It's also the only legal process I know, although again this influence spreads elsewhere in the judiciary, but so far it's the only legal process I know where the subjective wishes of the plaintiff are elevated to the level of law. In other words, if the only requirement in a divorce finding is that the marriage has irretrievably broken down, then the claim of the plaintiff that the marriage is irretrievably broken down is true by virtue of the fact that it's stated. So the preference, the choice of the plaintiff is elevated to the level of a legal finding, and that enables the judge to act against the defendant. Again, even if the defendant is legally unimpeachable, if the defendant has done nothing legally wrong, just by virtue of stating that there is a complaint that the marriage has broken down, well, therefore the marriage has broken down, and therefore the judge can act against an innocent defendant. And again, ignore the fact that the plaintiff thereby is at the same time breaking what should be a legally enforceable contract.
Just on this idea of the marriage contract, the term marriage contract, or even the idea or the concept of a marriage contract, is one where the parties have obligations to each other. It would appear today that the marriage contract, in effect, no longer exists, given that one party can arbitrarily and unilaterally end that agreement and then inflict upon the other various difficulties, such as forcing someone to pay alimony or child support or so on, where that person, as you pointed out, has committed no crime or is guilty of no misdemeanor. And there is this that I've observed where, say the wife is elected to pursue a lesbian lifestyle, for example, and she's free to go and do that and enforce the ex-husband to actually pay for her new lifestyle. And there's a general sentiment, certainly in the legal profession, that I've come across, which suggests that given her lesbian lifestyle, she's unable to secure a man with an income to pay for her. Therefore, her ex-husband now must pay even higher amounts of alimony and give over more of his assets, and a greater proportion of the house and his retirement savings. He must give over more of that to compensate her for her now more dangerous life choices, and that's done without any reference, as I understand it, to any legality, but rather as an arbitrary, an ideological determination that has no foundation in any form of law, certainly not common law and civil law and the likes, or even the old canon law, as I understand it. So this changes the very concept of jurisprudence into one where a judicial officer, and some may say activists in many cases, can arbitrarily determine an outcome and inflict financial punishments upon someone who's committed no crime, simply based on an ideology which cannot be challenged. And if we look at, say, the media today, where people who don't hold appropriate views can be savagely denounced by usually with invented crimes and smears and slurs. And this is not dissimilar to certainly what I've seen in the divorce courts, where the burden of proof that one party meets is very high and requires evidence of the highest standard, whereas the other party has a very low bar of evidence where they can effectively make any accusation. And even to the point where I've been in divorce courts where I've watched the judge invite the other court operatives to jeer and sneer and laugh at husbands collectively, and this is an abomination that's almost unspeakable in its it's reminiscent, in my view, of totalitarian courts where these sort of things were commonplace, where people will be dragged in on some trumped-up misdemeanor or some invented crime, and then they were subject to, in effect, organised humiliation and having their assets stripped from them when they've committed actually no crime, nor has the state actually gone to prove a crime, but rather has determined an ideological crime has been committed, or a crime against an ideological concept which is not codified in any law. Is this the wider issues contained in there? Is this something that you've noticed and have commented on?
Well, yes, this is a theme that this is a theme I spoke about last weekend. Starting at the most basic level, the very concept of no-fault justice is a contradiction in terms. I mean, you cannot have justice without recognition of fault. Otherwise, there's no point of a judicial proceeding. And this is the kind of central, the most basic flaw in the whole system. And from this, a whole series of injustices and corrupt practices proceeds. Again, as you say, as you alluded to things like spousal support and child support. These have nothing. Well, first of all, it completely negates the concept of justice within the courts. It means that the courts are not really courts at all. They are administrative agencies that are applying a predetermined outcome. Basically, they're functionaries because the courts are not concerned with justice. And once they stop being concerned with justice, they start being concerned with it. They start dispensing injustice. And this is precisely what they're doing, as the examples you gave referred to. For example, the child support system. Again, let's take it in order. Okay, first of all, the divorce itself is inevitably granted without any recognition of fault or justice. It's simply granted at the request of the plaintiff. Then after that, the next step is usually the child custody order, and custody of children is also given without recognition of fault, so that the spouse that commits adultery, or the spouse that deserts the home, or the spouse that commits domestic violence can get custody of the children. So the children can go to the spouse that abandons the marriage, that breaks the marriage contract, or that brings a groundless divorce. The third step is the child support order. The child support order is also given without concern for justice. So that not only does the guilty spouse can get the children, the guilty spouse can get a nice income from the innocent spouse in the form of spousal support or child support. So because of the concept of the best interest of the child, the spouse that wins the trophy of the children also gets to plunder the other spouse for his income and to get paid very generously, tax-free income, ostensibly for the children. But I showed that according to reputable economists, very little of the child support actually goes for children. It's mostly a profit for the divorcing spouse. To the point where, and so flagrant is this injustice of child support going to the spouse that is from the innocent spouse to the guilty spouse, that you even have cases where children, adolescent boys who are raped by adult women, statutorily raped, according to the law, this is a criminal act, and yet the boys must pay child support to the adult women who raped them, because the child support order has nothing to do with the justice and nothing to do with the criminal act. So in this case, the old common law principle that a criminal should never benefit from his or her crime is completely violated. And an adult can commit statutory rape against an adolescent child and collect child support from her victim.
I've come across noticed cases like that. There was one recently that I noticed where I think he was 13-year-old boy, one of the Pacific Islands, and there was an encounter along the lines that you mentioned, and so he was being coerced by the social workers to go and deliver newspapers on his push bike, and so the 20 or 30 bucks a week he got, and they were going to deduct some child support from that, which seems like an ideological crusade rather than anything that's going to yield benefit. But the story that I read was trying to spin it that they were teaching these errands evil, but I don't perceive that the 13-year-old boy and the 22-year-old woman, I don't perceive that he was necessarily the evil party that premeditated this. But one of the other things that or among other things that certainly others have commented on, and I've noticed observing the divorce system, was even though there's no illegality, the court is quite keen to place very onerous and restrictive orders, typically on the male, and then it's almost impossible for him not to transgress. And at the point he transgresses, he is then in contempt of court, which then introduces the ability to effectively inflict criminal penalties. And so there's an attempt to shepherd these people, to place the onerous order that if not difficult, it's impossible to meet the terms of. And then once those terms are transgressed, which it's almost inevitable they will be, given how onerous they are, then that triggers the contempt. So that seems to be a set piece 3-card trick or 5-card trick that's being used there to create circumstances of criminality, so that then those punishments can be inflicted with they're in contempt of court. That legally and formally turns that person into a criminal by the act of contempt. But the act of contempt itself is used as a tactical and strategic weapon in the overall, some would say, in the overall ideological surroundings of these matters, where it's again coming back to the premeditated. It's a way of turning innocent citizens into criminals using technicalities, in this case contempt. And as far as I can tell, that's used quite casually and certainly frequently, based on my observations. And it's used, as I understand it, for these tactical reasons. Is that something you've observed also?
Oh, very much so. Yes, I mean it's amazing how quickly a divorce proceeding, what seems like a fairly low-level civil procedure, can quickly turn into criminal proceeding very fast. And what's amazing is how many different ways there are doing this. There's so many different ways of turning the man into a criminal, the father, in a divorce proceeding into a criminal. He's a criminal if he tries to see his children without authorization of the court. He's a criminal if he's accused of domestic violence or child abuse. He's a criminal if he cannot pay the child support that's ordered ad hoc against him in a matter of minutes. He can even be a criminal if he doesn't pay an attorney that he has not hired. In other words, he can be ordered to pay the fees of attorneys that he never hired and whose services he never requested or asked for. He can be jailed for that as well, held in contempt. In fact, I even have an article from the New York Times, of all places. Usually, the New York Times is an apologist for the system, but they even have a title saying, indicating how fast the divorce court becomes a prison sentence. And they're referring to this practice of ordering litigants, innocent litigants, legally unimpeachable litigants, to pay the fees of attorneys and other officials that they never hired. So it's a racket, it's a shakedown. It's a system of legalized government extortion. And as you say, it has no basis in due process of law. This concept of contempt of court means that there's no trial, there's no formal charge, there's no jury. A judge can simply issue an order to a defendant who's legally innocent, an impossible order that the defendant cannot possibly fulfill, and then immediately jail him for failing to fulfill it. Child support orders typically are backdated. So the defendant the recipient of a child support order is an instant criminal. He's a criminal the moment he steps out of the courthouse. If the backdating is far enough, if the child support order is high enough, he's a felon the moment he steps out of the courthouse. Just simply by judicial decree. It's amazing that something like this can happen in a free society, but it's happening on a huge scale.
This concept of administrative deeming, that seems to be, not seems to be, in my view at least, it is very much part of the system where, as you say, some sort of child support apparatchik, and they're not usually very well paid people, and they're typically activists of the first order can simply, as you say, say a man is hasn't paid child support, or here's one case I've just got it in mind now, and this was actually a work colleague. He'd had a liaison with a woman when he was like 18 or 19, and she'd said she was pregnant, so he paid her for the abortion, and he was told by her parents, don't come around here again, and he ended up working internationally and going away, so he lost touch with that sort of group of people. And then 14 or 15 years later, he suddenly gets a knock on the door, and it's, by the way, you owe 15 years of child support, which would have completely ruined the guy. And he sort of backtracked through it all, and based on the court documents, and given his work colleague, he shared some of these with me. But he had a situation where the young woman had kept the money for the abortion and decided to run the pregnancy through to term. Her parents were reasonably well-to-do. They later fell on stony times, so she then applied for government assistance. And this is where the administrative sort of deeming comes in. The minute she applies for government assistance, that automatically triggers the child support chasing. Mm-hmm. So it's not a matter if she wanted it or didn't want it, but her mere act of doing that automatically triggers that second phase. Now, once that's then triggered automatically and it's backdated, then that automatically triggers that man's criminality, because he has this backdate of 15 years of unpaid child support. So he's already starting from the position that he has this massive debt and that he's a criminal. Now, once he's deemed and administratively deemed as a criminal, no court of law has heard this yet. When he's administratively deemed as a criminal, that the various agencies then have the right to take money out of his bank account, to garnish his wages, to take all sorts of actions against him that he's powerless to prevent. So in this case, he's owed. They allege he owes I don't know, $200 and something thousand, which was a lot of money for him. It would have wiped him out completely. And so, but you can see here the steps. One, administrative deeming triggers a second, which triggers a third, which triggers a fourth. And then,
Right.
without a court having heard it, without any evidence being tested, without anything at all happening, he's a criminal, and he goes to put his card in the wall to get some cash out, to be told that there's get the print out, there's no money. Now the banks go along with this and just hand over someone else's money because they get and I doubt the lawfulness of the request, but anyone called John who lives at such and such address, give us his money, and the money can be taken and causing him all sorts of. Now once the bank takes the money out of his account, he's then viewed as overdrawn, so the bank can then inflict financial penalties upon him for being overdrawn, even though he hasn't drawn a cent out himself or hasn't created that situation. And this then cascades into other things where he can have the bank chasing him for payments because they've given all his money away. So there's all these automatic triggerings. Now, if the state was determined to be clear on this, they would have, I would have assumed, approached the young man and say, right, well, we need to do a DNA test. This is the evidence. The court hearing's on this date, and let's hear it in a court of law, an independent umpire court of law, and let's sort it out and see what we can work out from here. But there's no attempt to do that.
No.
The state steps in at the taxpayer expense and goes through all these steps, whereas the man has to somehow defend himself. Now, once all that's happened, he then tries to have the matter heard in court, but he has to wait 2 years before the court has time to hear it. In the meantime, they have the arbitrary right to steal his money and garnish his wages up until the time that the matter is determined in a court. So he can't place a stay on the matter and say, look, you can't take any money until it's heard in a court. And if it takes 2 years, then everyone's going to have to wait 2 years. They can act immediately and arbitrarily. And this sort of thing, has this crept into other areas of law, this idea of administrative deeming and arbitrary and automatic escalation and triggering into other areas, which turns an innocent citizen without his knowledge or consent or a court having heard into a criminal, but not only in the jurisprudence of divorce, but also, as we're seeing perhaps more and more now, in determination of immigration claims and illegal alien status and so on. And I reference something that I appreciate you haven't had time to research yet, the recent case, which is in the public domain, of Judge Joseph in Massachusetts, and it's alleged that she let an illegal alien go free for ideological reasons, and not allowing an ICE agent to make the apprehension as he was lawfully prescribed to do. But without commenting on that specifically, just the concept of this, the jurisprudence having crept into other areas of law and having affected and infected the attitudes in so many different specialist areas, or whether it be child protection or whether it be illegal immigration, it's become an ideological exercise rather than a legal one.
Oh, absolutely. Absolutely. I mean, what we're seeing here, and I think the family courts are the most extreme version of the cutting edge of that, because we see this, these cases involving other areas of the law, immigration, and so forth. But these are actually, and they provoke quite a lot of public outrage. But they're actually quite mild compared to what goes on in the family courts. And the family courts are far more authoritarian and repressive. And in fact, I call them the most repressive government machinery ever created in the English-speaking democracies. I know it's not as extreme yet in Australia and Britain, but in certainly Canada and the United States, this is extremely repressive. And there's nothing like it. I mean, terms like judicial activism and judicial liberalism don't even begin to describe what's happening in family courts. It's far more extensive than that. As you say, they resemble the courts in revolutionary courts and totalitarian societies like the Nazi Hitler's what do you call them? The courts that Hitler.
The People's Court.
Yeah, the People's Court, the Volksgerichte, and the courts in revolutionary Iran, and of course in the French Revolution. These all created these kind of kangaroo courts that were explicitly political. They were designed to punish people as a class, designed to punish people for the group that they belong in, rather than for their actual deeds themselves. And this is exactly what's happening in these courts. It's all driven by ideology. To some extent, it's also driven by money, but I think its ideology is really what started it.
I've asked a number of legal professors and those who professors of jurisprudence and asked, do you teach about the great miscarriages of justice, whether it be the Nazi People's Court or the Soviet show trial courts or the Inquisition or any kangaroo court situation, witch trial courts and things of that nature, and say, well, do you teach these to students? Because the activism is being taught that it's just and good to let illegal immigrants off, even if they have committed crimes. But it's the great miscarriages of justice, because the justice only exists as long as the state is prevented from forcing its political will onto independent courts of law, and particularly where there's limited codification of law in the case of for example, divorce law and so on. But these professors don't seem, not only don't teach that, but they don't seem to think it's even relevant. Well, why would you want to teach that? Why is that important? And of course, it's vitally important to understand these things, and anyone that studies any sort of history of this. One of the great miscarriages of justice, of course, was during the Nazi era, where any Gentile could accuse any non-Gentile of some form of misdemeanor, so just looking at them, and that was enough. Without evidence, the allegation was enough to have a non-Gentile person dragged into the court, and if the summons was sent to the wrong address, or even if I forgot to put it out there, a police would come along and drag the poor person into the court, or they would get and it was designed to humiliate and disenfranchise. So they would say, well, come to a court on this date, but in the very Kafkaesque sort of way that Central Europeans seem to be quite good at, is the court hearing would actually be in another court 20 miles down the road, and so the case could be heard in absentia. Of course, it was set up to be like that. But effectively, these people had no legal rights. The allegation was considered as fact, and they had to prove that it didn't happen, which means they needed some very good evidence that they weren't in the town at the time, and they needed the people who were Gentiles because non-Gentile evidence was considered to be of lesser value, and so on. So all these types of things, the mechanics and the process of disenfranchising innocent citizens, doesn't change over time. Whether it's the Nazis doing it, or the Soviets, or indeed the Inquisition or the witch trial, it doesn't matter. That the mechanical process to disenfranchise people stays the same, and yet somehow we haven't, as a race, learned to say, well, gee, that's not a very good idea. We don't really want that. And a lot of the people that make a huge noise, as far as I can tell, that make a huge noise about the justices of the 1930s and 40s in Central Europe are some of the main people pushing the idea of this arbitrary ideological jurisprudence today. And out of all people, you'd think the lessons would be learned there. But it appears, certainly on my evaluation, it appears that it hasn't been. And while there are so few people who are prepared to resist these incursions into impartial, independent due legal process and clear and defined and absolutely, we're going to continue having these problems for history, and history will repeat itself. Having said all that, firstly, do you agree with that view generally, and or part of it, and how could we prevent this? Because history is repeating itself now, as I see it, and what can we do to stop it?
Yeah, no, I mean, no, you're absolutely right. I mean, you can see how there's just a complete, suspension of the very concept of the rule of law. In fact, one of the things I did in the lecture last weekend was I ran point by point down the Bill of Rights, and I do this in the book also, an earlier book, and show how virtually every principle of the U.S. Constitution and more largely, principles of the common law are just completely ignored or overturned by these courts, and it's again for ideological reasons. As you mentioned, ex parte proceedings, trials in absentia, ex post facto laws, bills of attainder, all of these things, which are explicitly prohibited in the U.S. Constitution and implicitly prohibited in the common law system, are simply ignored. The contract clause of the Constitution that says that contracts must be enforced is ignored. So the very habeas corpus, which goes all the way back to Magna Carta, is also ignored in the family courts. So it's really quite astounding this kind of thing happens. As far as what can happen, I mean, what we can do about it, in terms of the legal mechanisms, I mean, it's really quite simple. The legal remedies for all of this are very straightforward and very simple. You simply enforce the Constitution, you enforce the common law, very basic concepts like knowingly false criminal accusations of domestic violence, for example, or child abuse, should be punished. Most people expect that knowingly false accusations will be punished in a court, and yet they're not. As more recently we've seen in rape accusations, knowingly false rape accusations are not punished. So simply enforcing the basic principles that most people assume are enforced would solve this entire problem. Now, that's very easy to say from a legal standpoint. From a political standpoint, of course, it's much more complicated because all of this is political, and you need to build the political will, the political coalition, the political strength to see that this happens. And for that, there's no substitute for citizens and others, such as the media and my colleagues in the academic world, to start doing their job, to stop ignoring this. And when I say ignoring this, I mean the media ignore it, the academics ignore it, and most citizens themselves ignore it. I mean, we're all ignoring it, and it needs to be. I mean, what you're doing is what needs to be done. We need to create. If the established media won't focus on this, then we need to create new media that will focus on it. If the existing scholars and academics and intellectuals won't pay attention to this, then we need to create new ones. I work in a college that at least claims to be an alternative to the mainstream academic institutions. So, I'm in a position where I can focus on this more than most people who are employed in the academic world, especially those who receive government funding. So, but there's no alternative to citizen vigilance. There's no alternative to those of us outside the government, whether it's in the academic world or the media or just ordinary citizens or the churches. That's another sector of society outside the state, which traditionally is a watchdog, is a check on government power, and it's another one that is silent. It's another watchdog that's become a lapdog. So, I would list those institutions: the universities, the media, the churches, and ordinary citizens all need to just be vocal about this and step up and take the initiative that's required to expose this and to bring this to public view.
I agree. Just for listeners, you mentioned the attainder. Attainder, as I understand, and correct me if I'm wrong, is something that's initiated by the government or by the executive of government, which accuses a private citizen of a wrongdoing and predetermines their guilt. So they're really being dragged into court just to be verbaled and fined or imprisoned in some cases. And this was particularly the case, before the late 1600s in Britain, where the government could bring, particularly the Middle Ages, could bring and just drag people they didn't like into their assets or find them on again a predetermined. So they effect weren't allowed to bring witnesses in their defence or even to mount a defence. Their guilt was predetermined, and that's is that your understanding of attainder?
Yes, an act of attainder is a legislative direct declaration of guilt. So, in other words, the Parliament or the legislature passes a bill that's saying that somebody is guilty of a crime, without a judicial process, without the usual trial and jury and so forth. Obviously, this is a miscarriage of justice. You might wonder, why does this ever happen? It happens always for political reasons. It's a very old practice in political in times of political turmoil, and it's used for one purpose. It's an admittedly extreme measure that is used for an extreme purpose. It's used to punish political enemies that cannot be punished with evidence in a court of law. The most famous bill of attainder was probably against the Earl of Strafford in 1641 during the English Revolution, when Parliament passed a law declaring that the Earl of Strafford was guilty of treason, and they proceeded to execute him without a trial. Well, it's amazing that this is happening now in family court. Well, I shouldn't say family court. It's happening in modern democracies. Parliament, the U.S. Congress, rather, has passed several acts of attainder. The Elizabeth Morgan Act declared a father to be an abuser. He was never accused in a court of being an abuser. He was never tried in a court of being an abuser. The U.S. Congress passed a law saying he was an abuser, and they separated him from his children, his daughter, for years. The Supreme Court, 6 years, this was a textbook act of attainder, yet it took the Supreme Court 6 years to strike this down, during which time the damage was done. They said explicitly, the U.S. Supreme Court said explicitly, Congress very clearly passed an act of attainder in flagrant violation of the Constitution. Why it took the Supreme Court 6 years to act, I don't understand. And the damage was done. The daughter grew up permanently estranged from her father. There have been other examples of this, of the Deadbeat Parents Punishment Act. It simply declared American citizens to be guilty of crimes, even though they hadn't actually been tried for any crimes. Ex post facto laws are another example of this. Laws that are created after the fact. No-fault divorce laws are ex post facto laws because they were enacted and they governed marriages that had been contracted before the passage of the No-Fault Divorce Act. So they changed the terms of marriage after the fact. The child support, what was it called? The Child Support Recovery Act in American law was passed that made child support arrearages that had already been accrued into criminal acts. So they weren't criminal at the time they were accrued, but Congress passed a law making them criminal after the fact. So these are, again, ex post facto laws, specifically prohibited in the Constitution and long prohibited in the general common law. But, this happens all the time.
Yes. I urge everyone to have a look and have a listen to Professor Baskerville's talk that was in Louisiana on the weekend of the 27th, 28th of April. And there's going to be a link below to that. And also both of Professor Baskerville's books. And have a look on Amazon at the comments as well about the books. Some of them go into some useful detail on some of the issues in those books, and they're definitely worth listening to. Now for people who've I'm very grateful for anyone who's lasted right through to the end here. If there's anything you'd like us to cover in future talks, not specific cases necessarily, but generally along the lines of the corruption of jurisprudence, and particularly, of course, in the area of divorce law, let us know, and we can have a look at some of those topics and include them in if we can, in future conversations. But again, Professor Baskerville, thank you very much, and I look forward to the next conversation.
Good enough. Well, thank you very much. I appreciate it.